Hi, I'm Ksenia Yasnova, Public Relations Specialist of the company RosCo. In connection with the employment of HQS, employers have a number of obligations, including notification of the regulatory authorities about the payment of wages. What is the deadline for submitting this form? What threatens the employer if errors crept into the submitting notice? Find out right now. Employers as well as customers can attract highly qualified foreigners, HQS, to work in Russia. If the host party does not pay the salary or remuneration of the HQS, then it will lose the right to involve such specialists in the work. In this regard, the receiving party has certain paper obligations. One of the obligatory forms is the notice on the fulfillment by employers and customers of work services of obligations to pay wages to a foreigner. It must be filled out according to a strictly defined template, which is approved by order of the Ministry of Internal Affairs of the Russian Federation. Inattention to filling out the form, as well as delay in its submission, can cost the employer dearly.
When and where should the notice be given?
Notification is given once a quarter, and not later than the last working day of the month following the quarter. For example, a notice for the second quarter of 222 must be sent by the 29th of July 222. A notification is submitted to the Territorial Division of the Ministry of Internal Affairs of Russia. The easiest way to do this is through the Public Services website. An enhanced qualified signature is required to send an electronic application. If the company does not have the option of electronic filling, then you can send by mail or personally bring the notice on paper.
What is the danger for the employer of incorrect filling out of the notice?
Failure to file a notice within the prescribed time limit or mistakes made can result in a hefty administrative fine. The company is waiting for a fine in the amount of 400,000 to 1 million rubles, and an official can be fined from 35,000 to 70,000 rubles. Moreover, the amount of the fine is calculated separately for each such HQS. If there are several of them in the company, then the size of the fine reaches astronomical values and may put under attack the existence of the company.
Can an employer hope for a reduction in fines?
In the event that nevertheless flaws were made in filling out the notification, then you can try to reduce the amount of the fine. For example, the employer mistakenly indicated the dates of conclusion and the validity period of the employment contract with a foreigner, as well as the wrong date for issuing a work permit. The company was fined 400,000 rubles. As a result of numerous legal battles, this offense was regarded as insignificant, but even if the notice is filled out of time, the violating company has the right to apply for a reduction in the lower limit of the fine. For example, in connection with his admission of guilt, as well as a difficult financial situation, the amount of the fine can be halved, up to 200,000 rubles. Note that not all courts go for a reduction in fines, so a late notification cost the company a fine of 500,000 rubles. In order to avoid penalties for careless completion of the form, you need to carefully follow the instructions for filling it out. You cannot use abbreviations and various contractions. If an error is made while filling out, you will have to fill out the form again. After all, corrections in the form are not allowed. The employer must also monitor the relevance of the form to be filled out. In the case of electronic filling, this problem will not arise, and with a paper version, an outdated form may be issued. I'm glad you watched the video till the end. I'm Ksenia Yasnova. If you have any questions, feel free to drop a comment, and RosCo specialists will kindly answer them. And of course, subscribe to our channel, where you'll find loads of useful information, not only for your business, but also for yourself. Stay in touch, stay with RosCo.